Oregon is another state that recognizes the reasons for champerty doctrine ended long ago, making it an archaic relic that has no place in modern law. This recognition is not a recent one. It came in the 19th century in a case arising from a transaction very much like a modern litigation finance agreement. There, the Oregon Supreme Court held such agreements are enforceable. The case was Brown versus Benet. It arose when Benet was appointed as the executor of the estate of his business partner, Mansett. Benet asserted a claim against the estate for his share of the partnership interest, but Mansett's heirs disputed that claim. Benet wanted to pursue legal action against Mansett's heirs, but he lacked the funds to do so. He contracted with Brown, assigning Brown half of his proceeds of the legal action in return for an advance of funds to be used in the litigation against Mansett's heirs. When Benet prevailed in the litigation against the Mansetts, he refused to pay Brown according to the contract, contending that the agreement was void under the doctrine of champerty. The trial court rejected Benet's argument, ruling that the contract was enforceable. Benet took the case to the Oregon Supreme Court. The Supreme Court began its analysis by recognizing the contract between Brown and Benet would have been void under the doctrine of champerty. But it also noted there were good reasons to question whether the doctrine should have contemporary application, because it was originally designed to prevent members of the nobility from using others' litigation as an instrument for harassing their enemies. In this connection, the court considered the modern version of the doctrine and the justifications for it. As the court explained, upon modern construction, the doctrine of champerty and maintenance as regards a layman is confined to cases where a man, for the purpose of stirring up strife and litigation, encourages others either to bring actions or to make defenses which they have no right to make or otherwise would not make. Such interference is considered as having a tendency to pervert the course of justice. The gist of the offense consists in the officious intermeddling in another suit, and contracts not within the mischief to be guarded against should not be held to come within the rule. The doctrine of champerty is directed against speculation in lawsuits and to repress the gambling propensity of buying up doubtful claims. It is not and never was intended to prevent persons from charging the subject matter of the suit in order to obtain the means of prosecuting it. Thus, the court concluded the doctrine could have no application when a person invested in a well-founded legal claim. It is a shame so many contemporary courts and commentators have still not caught up with the Oregon Supreme Court. If you need help with litigation funding, call or email me today.